Good morning, everyone, and thank you for joining our webinar today. Today's topic is Your Workplace in the New Normal, hosted by the Florida Municipal Insurance Trust through the Florida League of Cities. My name is Ron Peters, and I'll be moderating the presentation and joining in on the conversation. I'm the Director of Risk and Safety Management for the FMIT, with a team of 5 consultants covering the state. I've been with the League coming up on 13 years. Joining us today is Michael Spellman, attorney with Sniffen and Spellman, PA. The firm handles the Employment Law Advisor, or ELA program, for the Florida Municipal Insurance Trust. In a moment, Mr. Spellman and I will attempt to tackle the current moving target of employment law and risk and safety management as Florida reopens. After the discussion portion of the presentation, we'll spend the rest of the time answering questions you may have. We may not be able to get to everyone's questions, but we will do our best. As a reminder, this webinar is being recorded and will be available to our members for their reference. Also, as a reminder, FMIT's Employment Law Advisor program is available at no cost to members of the FMIT family with liability coverage for employment practices. Call 888-368-FMIT Monday through Friday, 9 a.m. to 5 p.m. to reach an attorney who specializes in employment law. With that, I'm going to ask Mr. Spellman to kick off our presentation today. So please set the table for us as we get ready to dig in.
You bet, and thank you, Ron, and good morning, ladies and gentlemen. As we start to approach a return to what we call a new normal, this will not be easy, and it will certainly not be normal. I mean, we've all been through this weird and wacky, surreal time. You can't tell if it's a Monday or a Thursday. And through that, while we have been plowing through work and trying to stay focused, both individually and our employees have stress about their health, about their families, about their jobs. There's a lot of mentally challenging issues. And more than that, from a work standpoint, there's been a loss of routine. There's been a loss of momentum. There's been perhaps a forgetfulness about some of the muscle memory that we go through in the workplace. As leaders, public entities, and for this call, we need to be able to perceive our situation, be aware of it, and be aware of others are perceiving that situation. And while those perceptions of individuals may be much different from our own, obviously, there's a lot of different opinions about whether COVID-19 is as infectious as some, and recognizing what some of the emotions are that are out there. As leaders, we're going to have patience and adaptability. We're going to have flexibility and a balance of firmness and tact. We're going to need to develop policies, train them, enforce them, basically rinse and repeat. And you hear this from employment lawyers all the time about how important policies are, but I promise you, this is going to be a place where policies and communication is going to be key. Being accessible is going to be key, and having clear lines of authority and clear lines of communication will be extremely important. And above all else, and you'll hear this from me time and again, being fair and consistent with employees is going to be important. It's tough when you're in the weeds on this thing. Our goal is to get you up in the 50,000-foot view. As we start to approach the end of May, we're seeing various guidances and orders come out from our elected officials about returning to work. And I think everybody wants to return to work. They just want to find a way that can be done safely and fairly. So with that, I'm going to turn it over to the real expert here who can talk about safety in the workplace and some of the protocols that you can put in place or consider putting in place. Ron?
Thanks, Michael. Yeah, right. We've all said this before, and we hear it a lot, right? And you've kind of touched on it a bit. The new normal. Well, it's certainly unfamiliar, yes, but things are not standardized. Things are not. We can't consider them to be usual or even expected this part. So, yeah, when we say new normal, it's definitely new, but as far as it being normal, we're not there yet. We've got a long road to go. So what we've been able to offer our members, and some of you may have already taken advantage of it, we were able to put together a reopening decision guide, and that can be found on our website. And so what that is basically is that we didn't really come up with anything new, but we wanted to provide a roadmap and a framework to say, here's some things that you should be thinking about related to this whole reopening process. And I've been on some calls where, we've had members really kind of taking different perspectives, not that they were being irresponsible, but it just taking a different pathway. Like, everybody's coming back to work. Maybe some folks were not ready for that yet. So those are some of the decisions that need to be made. But related to this reopening decision-making guide, I'm just going to kind of hit some of these high level topics here related to that. And please, if you haven't had a chance to check it out, please feel free to check that out on the web. But one of the first things you want to be thinking about is, forming that reopening team. Now, for some folks, that's a little bit of a challenge. But I think too, because Florida, and this has been said many times, because of disaster recovery response that's already in play, it's kind of been a natural fit related to how we approach COVID-19. So with that framework in place, that's been kind of an easy process, taking that and then now taking this perspective of COVID. And then you want to make sure that you're, again, looking towards those federal guidelines, state and county guidelines, set reopening priorities, and that's all over the place with how you want to go about that. The staffing requirements, what about public access and prevention strategies? Many things that we need to consider. Facility readiness and maintenance strategies. Maybe you've had a building or facilities that's been sitting for a while. Have you really taken a look at how that will reopen? And what about vehicles that have multiple users? All those things. So, and then that reopening team, monitoring and evaluation. So I know a lot of folks have probably, they're tired of hearing about guidance, right? But we want to make sure that we're following some pathway related to that. So again, we do have that available, and through our consultants across the state, our guys can come and kind of walk you through some of these processes, or just provide, maybe another set of eyes to take a look at your process. And also one thing that's pretty cool, Johns Hopkins Public Health, they actually took the hierarchy of controls and injected COVID-19, and that's also in our reopening decision guide that's on page 16. And I think it's kind of a cool thing, especially for us safety folks, to kind of have this in our mind, starting at the top of that inverted triangle, the physical distancing, engineering controls, administrative controls, and then PPE. And it's also broken down for us on another level. So kind of a good reminder, and I just like how they took that hierarchy of controls and they adapted it to COVID-19. So we have processes in place to kind of approach this, but I think Michael, as we've discussed and kind of talked about, there's just a lot of what ifs and how should we approach. My wife is a nurse, and the discussion of even wearing gloves in an office environment can kind of come up. And so how do you deal with that? Well, while the guidelines, CDC, OSHA will tell you that wearing gloves is probably the most effective way to protect yourself on that level, but you have to have a lot of discipline to do that. So my wife, being a nurse, she tells me that the doctors and the nurses are not walking through the hospital with gloves on, but when they go in to give care, they put on their gloves, and sometimes they change their gloves several times depending on what type of care they're giving. And then when they leave the room, then they're without gloves. So working even in an office environment, some folks may want to, I must have gloves. But while that's true, that's a high level of protection. They must have the discipline and the frame of mind that as soon as they touch their face with their gloves, they defeated the whole purpose. So as you can see, there's a lot of different choices that need to be made in the office environment and other areas that we're looking at. So Michael, I don't know if you want to kind of jump in and maybe talk about some of the things that you've been thinking about related to employment practices and things of that nature.
Yeah, I mean, sure, absolutely. And It is about discipline. I mean, it's so funny. I'll come in my office or what have you, and I'll wash my hands thoroughly. And what do? I grab my cell phone. Well, if my cell phone hasn't been wiped with a Clorox wipe or whatever. So there's all these various issues that some of us we're not used to. I mean, this is something we have to get used to. But more importantly than that is how does that translate into the workplace? And I will tell you that in preparing for this talk, so I've given several webinars for the FMIT, which hopefully you were able to get some good information from. And in interpreting things like the CARES Act or the EFMLA, those were pretty tangible, objective laws that I could provide insight on. In preparing for this one, the common theme that keeps coming out is flexibility, adaptability, patience. And I think a lot of that is because we just don't know where this is headed. We don't know if there's going to be a resurgence. We don't know if there's going to be a different virus in the fall. We just don't know. And so what I'm going to talk to you about is what some of the potential pitfalls, what some of the laws are out there, and trying to cut through all these various guidances. These guidances come out from various agencies. You see all sorts of stuff on the internet from law firms and from SHRM and from various groups. And a lot of them aren't talking to each other, and that makes it very frustrating to try to get down to the real meat of the matter. And so what I'm going to try to do is distill this information. So Ron mentioned both the CDC and OSHA. Both of these organizations provide timely and very good guidance. Now, it is true that OSHA does not apply to public entities, but insofar as defining what a safe workplace looks like, it and the CDC, I would submit to you, are the best guidances. And what I think you're going to need is, and this is in complement to what Ron said, is you're going to need somebody within your organization that is the point person that reviews these guidances and continues to monitor and adapt as things change. So one of the big areas that I'm concerned about for employers going forward is not the various alphabet soup that I'll talk about in a minute, like the ADA, FMLA, et cetera. It's actually negligence. So the Morgan & Morgans of the world and various local law firms that do personal injury, you might have noticed this, but at least in Tallahassee, they all have new TV commercials. And they all say, we're here for you. And, maybe they are, or maybe they're out for themselves. But the bottom line is that I think, and I see this around the country, where personal injury firms are going to try to find ways to sue employers and get around the workers' compensation exclusivity. And so that's a difficult burden, but you think about things like sick building syndrome, which ironically came about in the 1970s from a virus that spread because of poor ventilation in a hotel. But that is something that I think you're going to see novel legal theories try to come forward, either as class actions or as individual actions. And so the things that chip away at the workers' compensation exclusivity are things like the failure to warn, the failure to test, the failure to properly disinfect. And so to avoid these things, I think what you're going to need to do is develop policies about testing, develop employees, develop policies about what if scenarios. What if somebody does test positive? Do you have an isolation plan? You need policies about cleansing, and you need to think about all the work environments. Desks, where do your customers come in? How about work trucks? How about work equipment that is necessarily shared by like folks in public works or in your utilities departments? How about your elevators? What type of cleaning regimen do you have for that? What type of intervals are they cleaned on? Is it daily? Is there a deep clean quarterly? I mean, these are all the things that I think you need to think through and create policies about. How do you avoid large groups in shared areas like vending machines, coffee machines, microwaves? Should you put up glass barriers? Should you find a way that there is a touch-free or hands-free business, whether that be through a credit card or what have you? How about travel for your employees? I think figuring out what is really essential and curbing travel is a critical thing. So, the negligence side of it, which I really very rarely discuss because it's usually a workers' comp thing, but I'm watching these lawsuits pop up around the country. I haven't seen one in Florida, but I still remember when Skip Campbell brought that massive class action about the courthouse in Broward County. And it just, I think that there are some similarities. And so I think, again, right, creating a policy, training on the policy, adherence to the policy, and frankly, punishment for failing to adhere to the policy are all going to be very, very critical areas. So
Hey, Michael.
Sure, go ahead, Ron.
Just if I may, just to kind of touch back on the OSHA side of things, and you're exactly right. State of Florida is not under OSHA. Some states are. There is a federal OSHA for some states, and they follow the plan. So what we need to be concerned about here in Florida is that you're right. The attorneys will take a look at the OSHA standards, and they see that as minimum guidelines, and that's pretty much used across the board for the entire country. So they see OSHA, even though OSHA in Florida, they have no jurisdiction, they cannot come in and fine. That's not possible in Florida, but attorneys will look at that minimum guideline, and then OSHA points to a lot of manufacturers' recommendations. So those are some of the things that we need to look to and be mindful of. And there's something called the general duty clause in OSHA that says if there's a known recognized hazard and you don't address it, there's going to be an issue. And that's a paraphrase, but so that puts all of us on notice that, and especially now, there's a known recognized hazard among us. So what are we doing following best practices, industry standards to ensure that we're addressing this process across the board? And it's a bit of a load to carry. It's going to be tedious. But again, that's one thing that our consultants are good at, is helping come alongside to help folks build their safety programs and maybe look at some of these things as well. So I just wanted to add that from the OSHA perspective.
Yeah, and absolutely. And I think, in all of this, I think that as an employer and as a public employer, the ability to act deliberately, thoroughly, and not impulsively is going to be important. Because I had a situation with an employer last week, and I said, what does this look like in a year to a jury? How are they going to assess what actions or reactions you took? And that, I think, is the prism by which we have to look at this. So while you may be in the weeds and you may have a frustration level with certain employees, and believe me, we all do. There's always one or two or a handful. What does that look like when it is viewed by folks a year later who don't know anything about you and are judging this for the first time, given what we know right now? And I think that is why we need to be very, very careful. So the biggest federal law that I think is going to be applicable here is the Americans with Disabilities Act. So remember that the EEOC does not allow for medical inquiries except now, because there is a pandemic. And so the EEOC has loosened their grip on these medical inquiries. But what I will tell you is that they need to be limited. The medical inquiry, which can be done by taking an employee's temperature every day when they show up for work, and even developing a questionnaire that asks, have you been around, have you been exposed to anyone with COVID-19? Have you been at a location that is considered a hotspot? I mean, these are the types of things that you can ask of your employees, and they have to answer them. Their refusal can be the basis of discipline, but again, patience and and kind of bending over backwards is important here. But what I think is really important is developing a policy that all employees can see what it is you're going to do. So if you have a specific screening process you're going to utilize, whether that be that your city is going to take a temperature, or you're going to contract with a vendor, some healthcare group that is going to come do that, to have that in a policy, to establish what the benchmarks are for passing the screening. Is it having a temperature below 100.4 degrees? Is it something else? What your expectations are for your employees' compliance with that process, and the consequences for their refusal to participate. How you will protect their employee privacy, and the consequences of an unsuccessful screen, that is, they test positive. I think these are all very important things that can be put into a policy. It doesn't take, weeks of subcommittees to come up with the language. I think this is something that can be done fairly quickly, but I think that the more you can be transparent and communicate this to employees, the more the expectation is out there. What happens if somebody refuses to participate? We'll have a discussion about that. Why do they refuse to participate? Is it a religious, is it based on a religious belief? Is it based on some other type of belief? You need to work through that. If it's just because they don't feel like it, or they don't believe that you have the right to do it, well, that's not good enough. If it's a religious belief, we need to kind of work through that. I'm not aware of any religious practice that doesn't allow for temperatures to be taken, but hey, I don't know everything there is to know. The confidentiality of all of this information is critical. So this is not about HIPAA. This is about the ADA. The ADA has its own requirements of confidentiality of medical information. It's not supposed to be kept in a regular personnel file. And so that needs to be in the policy as well. And you should already have that in place with any reasonable accommodations that you guys have encountered in the past. What is your isolation plan? So in my situation, I had an employer, somebody showed up, their husband had tested positive for COVID-19. Well, this person wasn't supposed to show up at work, and it created quite an issue at their workplace. Well, your isolation plan should send the affected employee home for a given period of time. It should have benchmarks for when they are allowed to return to work that is probably consistent with what CDC says. It should consider notifying the workforce that somebody has tested positive, but according to the ADA, you're not allowed to say who it is. Folks may figure that out. That's the practical side of it, but it's your job to just not confirm that or deny that. It is important to do some tracing as to who that person was around and perhaps put them in a quarantine situation. And then I think it's really important to have a policy where you're going to bring in a crew to do some disinfecting of the area that the person that tested positive was around. And so the testing right now is allowed under the ADA. It is for virus and diagnostic. There was a question that could come out about whether serology testing, that is testing for past infections for antibodies, is allowed, and the EEOC has still not commented on that. But what you can require is a fitness for duty for somebody to come back to work. I will tell you that one of the big issues here is whether or not you can require medical documentation. I think it's prudent, but a lot of these guidances are talking about how you can't be overly strict on that because doctors' offices are overwhelmed right now and they cannot produce the documentation. So, what this really comes down to is whether somebody's going to be penalized for not having a doctor's note. On the one hand, I can see you not wanting to introduce them into the workforce until you see documentation that they have been negative or what have you, symptom-free for a certain period of time. But on the same token, if their doctor cannot produce that note for a few days, should that person be penalized? These are the types of things that will have to be balanced and have to be taken care of in a reasonable fashion. The other thing from the ADA that I would tell you is, to the extent you have EAP programs, you want to publicize those more now, just so people know how to get in touch with them. There is a lot of stress and mental issues going on, there are a lot of folks that are scared, whether that be legitimate or not, and having the EAP numbers and contact information available for your employees is critical. The other area that I think is important to talk about is wage and hour. And so recall that exempt employees are paid a weekly salary no matter, if they just work 1 hour of a given week. But non-exempt employees are paid hour to hour. But what about testing? Does somebody have to be paid? And this is similar to the cases that have come out of the courts regarding what we call donning and doffing, which I believe last year, if you went to the FLC University, I had a question if anybody knew what donning and doffing was. And it's basically putting on protective gear or taking it off. So the question from the court standpoint is the donning and doffing a principal activity? Is it integral and indispensable part of the employee's activities? And what I would tell you is that where protective gear, where we're trying to maintain a safe work environment, checking temperatures is similar to donning and doffing gear that is integral and indispensable. So I think that is compensable time. And while there's no ruling on that I think is the better course of action. If you're going to make somebody get their temperature checked, I think that should be a part of their compensation. The same thing with donning and doffing PPE. If folks are going to have to put on personal protective equipment, they should probably be compensated for that. But let me tell you, there's a lot of people, and I think Ron can probably chime in on this, that don't understand, like he was talking about the gloves, they don't understand what cross-contamination is, they don't understand how to put on PPE, who don't understand how to dispose of PPE, and don't assume anybody knows anything. I think that it's worthwhile to go through an exercise, whether it be YouTube videos that you're able to share or what have you, on the proper way to put on PPE, on the proper way even to wash your hands. There are just a lot of people, and I guess I could sit here and say, what were you, raised by wolves? But it's not that. It's just that people don't understand what, epidemiology. They don't understand what's going on here, and so stressing that and emphasizing that is really critical. Ron, would you agree with that?
Oh no, absolutely. And personal protective equipment is only at the end of the day as good as the user, right? And it's really the last resort too. There's many other things that we want to take a look at, that whether we can use administrative controls or engineering controls, or just hopefully try to avoid the process altogether. So when you're wearing personal protective equipment, it's the last resort and really not what you should be wanting to do because of the hazards involved. So the proper use, proper donning, disposal, all of those things. And the kind of the tricky thing about the N95, if we didn't know what an N95 was, we've certainly heard about them. But even for an N95, and mainly those are being reserved for the medical professionals, there's supposed to be a fit test and a pulmonary function test because it is considered a respirator. And there's been stories of folks using N95s as they're driving down the highway and they pass out because they are not able to properly get the proper oxygen levels through that mask just because they have a deficiency. So it's very important, that we take a look at manufacturers' recommendations, the proper use for specific scenarios across the board. And I wanted to go back to and touch on the policy side of things, because that's where we're the safety geeks, and we kind of love to have a roadmap and policy. But as soon as you place a policy, and you would agree, in place, it has to be communicated well, administered well. If we build a policy and it just sits on our shelf, we're going to be held accountable for that.
That's exactly right. So Ron makes a great point, and I've said it several times. You can develop the best policy in the world. If you don't utilize it, if you don't train it, if you don't adhere to it, it's not worth the paper it's written on. And the problem is that it gets shoved right back in your face, right? This is your policy. What did you do to enforce it? What did you do to communicate it? What did you do to train it? and that's going to take a lot of effort on your part to develop it and train it and communicate it, and train your trainers on how to handle it. But I think that is going to be the key to having a consistent approach that everybody knows what is expected of them and what they can expect from you as their employer.
And documentation. Got to document all the training and everything that goes on. If you have good documentation, that's another plus.
And remember that applying these things consistently is really, critical. From if there's one thing employment lawyers love, is uniform and consistent application of policies, because so many discrimination and retaliation cases are what we call disparate treatment cases, where the person who is bringing a claim says, I was treated differently because of my fill in the blank, race, gender, age, disability, religion, what have you. And so it's important. And look, I get it that there's apples and oranges, and it's hard to sometimes maintain consistency. But this is where really the folks that are your frontline supervisors and one above them need to be trained, need to be acting in a very thoughtful manner, and need to be consistent. And again, documentation is what proves that consistency. I think I said in one of our previous webinars that I think that this is going to be a watershed for a lot of employment lawyers. I still believe that. I think there's just an element out there that's looking for ways to make money off of this, and this whole exercise of these webinars is to try to give you the tools to prevent those. And obviously, beyond the webinar, calling the ELA, we can try to work through developing these policies. We can try and work through individual situations where we have an employee and they have a situation. What should we do? These are all things that I think we could help with on individual bases, but I think that the development of policies is going to be a key here.
No, agreed. And let me just maybe shift gears here just a little bit related to that. So I know folks are again, and especially, we're kind of, we've heard about guidance, we've heard about all these things we need to do, and we need to do those things. But one of the things that, as risk and safety consultants that we're looking for a lot of times is how do we affect substantive change, right? We talk again about our processes and framework. Well, a lot of that has to do with behavior and culture. I mean, those are the things that drives the change, but how does that work? Well, everybody needs to be on board, right? And my team is going to roll their eyes as I say this, but everybody is a risk manager, right? And if we can just get that out there and get everybody to understand that we all manage risk, but how well do we do that? And so one thing that we're really excited about with what we're offering from our risk and safety department is that our team has put together a safety excellence initiative. And this is a voluntary program that we're just about ready to fully go online with. We've been working out some of the bugs. We've had some cities actually kind of pilot the program for us. So this is a voluntary program. There's no pressure as being part of the FMIT to participate, but the goal of this is to provide each city the knowledge and the tools to easily develop and implement that safety management system. And it's really, we're very impressed with what we're offering, because you can piecemeal it, you can take a little bit of it, or you can go as deep as you like. There's going to be an exhaustive document library that will pretty much take a look at every scope of work that a city is involved with. I mean, it's not complete, but it's taken us a good long while to load up everything onto the website. It's pretty impressive. And what it's also going to do is provide a benchmark for us to compare ourselves against best practices. So again, this is something that's voluntary, but we really want to, and it's really from an enterprise risk level that we're looking at here, taking a look at every aspect of what a city is exposed to and their processes related to risk and safety management. So here's a framework. A lot of folks already have good systems in place and they're already doing these things, while others maybe they've got bits and pieces. But what we're excited about is that this safety excellence initiative is really going to kind of give you that roadmap to kind of plow you through that whole process. So there's going to be there's self-evaluation checklists, there's behavior things that we can track, accountability issues. So again, we're really excited about this process to kind of help, and it's kind of timely now that, well, maybe it's time to look at our overall safety process, and we can help kind of build that program for you.
So let me touch on a couple of practical issues to consider as well. So one is as folks are returning to work, and you assess your space, consider how you can maintain some distance in your workspace. So we've had a lot of areas that have cubicles and things of that nature. Are those going to be good enough, or do they need to be spaced out, more than they are? Should you consider staggered reporting to work? Should your employees be staggered? For some of those, not Tallahassee, but for bigger cities that have mass transit where employees are using mass transit, should you consider having people report to work earlier or leave later so that they're not stuck on a metro rail or buses or what have you? These are all some very practical elements. The other thing is remote working. So, when we first got this thing going and we were talking about telework, because that was one of the things in the CARES Act, was that if somebody could telework, then they weren't going to be entitled to leave. And, my sense was that before this pandemic hit, that most employers did not want their employees to work from home or telework. And there was a resistance to that kind of request for reasonable accommodation. If somebody came in and said, I'd really rather work at home, most employers didn't want that happen. They wanted attendance. They wanted people to attend. Today, that paradigm has changed quite a bit. And I think looking at your essential duties of your employees, the question is, can folks work from home or can they telework? For exempt employees, that's easy. Insofar as you don't have to keep their time. But for non-exempt employees, it is not so easy. And what you're going to need are strict rules about when you do clock in and when you clock out, and what work you do and what work you don't do in those off hours. You don't want people, so you need policies on that, because you don't want somebody that says, well, I decided to start working at 10:30 at night because I couldn't sleep. Well, that's not your issue, but unfortunately, if they are working for you, and I know I've lectured on this before, then they have to be compensated for that. The law on wage and hour is they have to be paid for their work. Then they can be disciplined for not following the policy, but you need to have a policy. So that's one area of practicality I want to put out there. The other area is trying to divorce the best practices in the workplace from the politics of some of your elected officials. So obviously this thing has become a political hotbed. There are, all sorts of very high, strong opinions and emotions about this. And you probably work for entities that have certain people that are running for office, and they may take certain positions. But in almost every public entity I've ever worked with, the charter or the ordinances say that the elected officials are not in charge of the personnel. A city manager, a town administrator, a county administrator, what have you, that's the person in charge of personnel. And this needs to really be based on the CDC guidelines and the OSHA guidelines and some of the more reliable guidelines on the safest practices in the workplace, irrespective of what the politics of the day are. And I realize that that is not an easy task, but I think it's something that's very vitally important, because when the lawsuits come, it's not going to matter what the mayor or the commissioner was saying. It's going to matter what the guidances looked like and what the best practices were and whether those were being utilized in your workspace.
Michael, we have a question that I'd like to have you try to tackle here. It says, how are other governments dealing with employees flying for vacations? And then it says mandated quarantines. Some of our employees can work from home and others cannot. And they finish with trying to do what is fair.
Yeah, so I will. So that's a couple different questions, but let's talk about the one about employees going on vacation. So my wife actually works for the city of Tallahassee. City of Tallahassee has a rule right now that if you go further than a certain numerical mile radius, that you have to be quarantined for 14 days. We're trying to go to St. Augustine this weekend. She actually wrote her boss about, look, we're only going to go to our house there. We're not going to go to, any event. We're not going to do any of these things, and asked for an exception to the quarantine, and she received it. Now, is that necessarily the best practice? I don't know. I mean, I think a random number of miles may not matter. You look at what happened up in Albany, Georgia, and that would seem like not a hot spot, but one funeral turned into 70 cases of COVID-19. So I think as an employer, you have every right in the world to ask people to say where they are going for vacation, whether they've exposed themselves to a situation. And if they have, I think that you are perfectly within your right to require them to quarantine. This is going to be a moving target. Pretty much everything we're talking about is very fluid and can change, with the next set of test results. Who knows? But I think that you have the right to ask those questions, and you do have the right to quarantine. On the question of working from home, again, I think that is a question of essential duties. You look at people's essential duties and whether they can work from home, whether that's practical, whether their essential duties really require them to be in the workplace, and then you make that judgment call. But let me emphasize that all of these types of policies need to be done consistently and uniformly. So you don't just want to put the problem employee to work from home, right? Or worse, come to work. You want to be kind of blind to who the people are and more about the functions of the job, so that you don't back yourself into some kind of question of intent, or whether it was geared at a certain employee in a certain way.
No, very good. And we had a previous, what comes to mind, we had a previous conversation about being patient and generous with, making sure that folks feel comfortable, right? There was, in a previous call, we had a member talk about an individual who was cleaning gym equipment, and they thought and they felt that they needed to have some type of face mask or respirator while doing that. And then you can look to the manufacturer's recommendations for the cleaning supplies, and then it doesn't specify that that's needed while performing the cleaning function. That's something that you don't need to have, or you don't need to make available. But at the end of the day, at the end of the conversation, again, we're going back to perception. And if it makes that individual feel better, then why not have the city provide a surgical mask or maybe some type of cloth covering to, again, not that it would be considered negligent not providing it, but if it makes an individual feel more comfortable, those are some of the things that probably should be considered.
Well, that's exactly right. And, it reminds me of when the anti-harassment policies were rolling out in the late 90s and early 2000s, and perception is reality to a lot of these folks. And so what I mean by that is that while ultimately they may not be correct in their perception, at the initial onset of the perception, it needs to be taken into consideration. It needs to be validated that that is how they feel, and then it needs to be worked through. Ultimately, the last thing you want to do is terminate somebody who has some fear, founded or unfounded. If it has to result in that, it has to result in that. But what I would say is we want to check every box. We want to try every alternative before that, because again, in a year from now, when 6 or 12 disinterested individuals, but all of whom lived through this period, are judging the actions and reactions of the parties in front of them, I think they're going to look for, who acted irrationally, and I think employers already walk in with a bit of a burden on their back. I mean, the studies have been that jurors are usually about 2/3 are employees, not managers or employers. So you recognize that bias, and so what you want to show is, look, we tried everything to try to work with this person. They were unreasonable, and so that's why I think a lot of these actions are important. Remember, your emails are all public record, so don't careful what you put in writing. Careful what your other employees put in writing. But I think that's the real challenge here.
Yeah. Michael, a couple of great questions just in. Let me ask this one. Let me present this one. If an employee travels and then has to quarantine, then should they be required to use paid leave banks? There will be employees who take advantage.
Yeah, so I think so. I mean, if it's not business travel, let's say it's a vacation, and they decide they're going to go down to Daytona and have a big street party like they did this weekend, and that then falls into a quarantine situation, then yes, I believe they would have to use their personal leave. Now that also takes into account those set of facts. Let's change the facts a little bit. Let's say that they just have symptoms. Let's say they have not used any of the Paid Sick Leave Act dollars that are out there, or the leave that was out there. Then they might fall into that category. So I think it's all this stuff is going to be very highly fact specific, but I do believe that if people put themselves in this situation, then they're going to either have to use their leave or they're going to be on leave without pay in that situation.
Yeah. Here's another scenario. How do we deal with an employee that has exhausted the 12 weeks of FMLA leave and still is not wanting to return to work due to their child being considered high risk?
That's a really difficult situation, and it's probably going to be one that we're going to see more of depending on how schools are going to be staffed in the fall and what that's going to look like. My feeling, and I'm assuming that this person cannot telework, so they've used up all their leave under the CARES Act, both EFMLA and the paid sick leave, and they don't have FMLA, and so at the very least, they would, at the best, they would be on leave without pay. But if they are in an essential and critical type of position, then I think that there needs to be a dialogue as to whether or not there is anything that can be done either from a staggered work schedule or any other kind of accommodation that might be available. And barring all of those things, but again, I think that's a process that needs to be documented. But barring all of that, then I think you are going to hit a situation where somebody's going to have to be terminated. I mean, at the end of the day, this is about priorities. And while I am stressing to employers to be patient, and bend over backwards. It doesn't mean to break either. I mean bending but not breaking.
Here's another one related to summer programs. With the county and other summer programs now opening, what can the employer do with an employee that does not want to enroll their children in a summer program due to COVID-19?
So it's interesting, when the Department of Labor put out their guidance and they said there wasn't daycare or schools open, they didn't even mention summer camp, even though we were obviously going to hit summer camp soon. So to me, that tells me a couple things. One is that, you know, on a Sunday night, the DOL may decide to release another updated guidance, as they have done so many times over the last 6 weeks. And so maybe they'll give us a little bit of guidance on that. However, you know, as you all know, the EFMLA and the paid sick leave had some strict time constraints on it. And when those time constraints run out, then we get ourselves into the same situation as the person who didn't want to return to work. And so I think it's the same exercise. It's this, first of all, they're going to be on leave without pay. And then it's a question of, you know, is there anything that can be done? But my concern is that people who just choose, you know, to not use things that are available to them do not fall within those laws. And I've debated this with you know, other attorneys, and I respect their opinion, but I think that the Department of Labor used the word need in the regulations for a reason. And the analogy I give is, what if you have a divorced couple and they have shared custody? A person who doesn't have custody on a given week doesn't have a need for childcare. They only need the childcare when it's their turn to have the custody of the child. And so I think there's, you know, again, the guidances are not necessarily clear, crystal clear, or can answer all questions. And that's why I think employers need to bend over backwards. But again, at some point, there's just enough is enough, right?
Mm-hmm. Here's one related to travel into a hotspot. The question is, can we require an employee who is attend a funeral in Miami this Tuesday to quarantine and use their personal leave to do so? This person has already received more than 160 hours of paid COVID-19 sick leave.
So, you know, my answer, I might need some more facts, but
right.
I believe that, first of all, funerals are really dangerous places, as evidenced by Albany, Georgia, which, by the way, up here in North Florida, they call it Albany, Georgia, but that's for another conversation. But Miami is a hot spot. There's no doubt about it. If you have a bereavement policy, they might fall under that to quote unquote attend the funeral. But I think that they should be quarantined, and I think that again is either going to come out of their personal leave, or if they exhaust their leave, will be in a leave without pay situation. That's a harsh rule. I know that, and people want to attend funerals, but I think that they are putting everybody else at risk by coming back, and I think that you have to take into consideration your other employees.
Yeah, no, these are harsh times too, so that's you know, part of the balancing act. Here's another question. If someone is working intermittently from home because of childcare issues, do they get 10 weeks paid EFMLA after the 2 weeks of EPSL, regardless how many hours they work, or they are entitled to 10 weeks by 40 hours, which equals 400 hours of remainder for 2020? Yeah, kind of a detailed.
Like the old Saturday Night Live skit. I did not know math would be involved here.
Right.
So the bottom line is that between the Paid Sick Leave Act and the EFMLA, you get 12 weeks. That's all you get. And insofar as what that compensation is worth, there is a guidance about how you calculate intermittent leave, and I don't know it off the top of my head, but I can look that up and get back with you on that. I assume this is a full-time employee, but at some point they will, once they use up their 12 weeks, they've used up their 12 weeks. Now, I guess this depends on whether or not your entity does a rolling 12-month calendar under FMLA or does a calendar year. That will factor into this, although by this point we're almost to June, so if it's a calendar year, we really wouldn't have to worry about that. But I think I might need to drill down on the intermittent leave side of that. Obviously, the FMLA, just understanding intermittent leave with the FMLA was confusing enough. Throw this into the mix, it really has created a little bit more of a headache. But let me look into that a little bit further.
Sure. Looks like we have one additional question here remaining, and it's going back to summer camps. If the employer provides childcare or summer camp to its employees, can employees be forced to use the employer program versus using EFMLA leave?
So this was another debate I had with an attorney. I think so. I think so, because I think, again, that word need in the statute and in the regulations means what it says. And so if the employer is going to provide that service, then is the need really there? Now, the flip side of that is, God, be sure that that summer camp or daycare or whatever, has good disinfectant policies and all these kinds of things, because you'll have John Morgan showing up on your, at your city hall. But I think that if you have gone that far to provide that type of a service, that there is not a need, and that therefore using the EFMLA or the paid sick leave act to say I need to be compensated, I think that's unreasonable. I don't think that that's appropriate.
Okay. Well, we've got a few minutes remaining. We want to be mindful of everybody's time. Looks like we've taken care of the questions, and there may be some more that might trickle in. But at this point, Michael, if you just want to maybe think about tying some things together and maybe some closing remarks as we get ready to wrap this up.
Yeah, sure. Again, it's such a wacky time. I remember when this first got going, and there's a comedian who I follow on Twitter, and she wrote something like "Happy Friday," and it was like Tuesday, and we really didn't know. I mean, somebody said to me, "Did you have a good Memorial Day weekend?" I was like, "It was the same as everything's been the last 6 weeks." I mean, it's such a bizarre time, and what I'm seeing now is that people are just kind of getting impatient, and emotions are starting to run high. There seems to be, depending on what part of the state you're in, there's shaming if you do wear a mask or shaming if you don't wear a mask. And as public employers, we're all going to have to rise above that, and we're all going to have to try to get people back into the momentum, back into the routine, and to be, to be thoughtful of what others are perceiving or what others are going through. And that's not going to be easy. It's going to be quite a challenge. As you are trying to develop policies, as you're trying to address these individual issues, like some of the questions you came up with, people that want to go to a funeral in Miami, things of this nature, I would say use the ELA hotline. I mean, we're trying to address all these calls as they come in, and we'll do our best to answer questions on the fly. But I do, again, will say, be flexible, be patient, be compassionate and considerate, and work on developing policies, communicating them, and training them.
Well said. Looks like there's one additional question. Where can we find information on the Safety Excellence Initiative? If you just go on to the flcities.com website and then search under services and then insurance, and then you can go and you can find some more information related to that, or I'll be glad to give you more information about that directly. Well, I want to thank everybody for attending today. I think we would all agree we're hopefully starting to get things back to normal. We're certainly not there yet, but we want to keep the conversation going. We want to be talking amongst ourselves, talking about what's working, what's not working. So again, we appreciate your time, and just wish everybody a happy rest of the day. And thank you all for joining.
Thank you, y'all.